Good evening, everybody. It's great to see everyone for our 12th annual Community Justice Academy. I've been to every single one of these, and I know many of you have as well. And it's great to see everybody again. I'm super excited for today's conversation and looking forward to a very productive discussion today on the topic of consent. Wanted to thank everybody for joining us last week. Our victim advocates did a great job. We received really positive feedback on the conversation that we had last week. For those of you who don't know, my name is Ryan Mears, and I am the Marion County prosecutor. I've served in that position for the last 3 years. I've been a deputy prosecutor since 2006, and one of the great things about my job is I get the opportunity to have meaningful conversations with people in the community. And I look forward to the Community Justice Academy each and every single year because we really are able to do a deep dive on a given topic as it relates to criminal justice issues. So thank you very much for joining us and allowing us this opportunity to have this discussion. Because of everything that's been going on in the world, we have not done one of these in person since 2019, but I'm very happy to report that that all changes next week. Next week, we are once again going to be live and in person at the Library Service Center at 2450 North Meridian at 6 o'clock sharp. We're going to talk about the root causes of violence. We have a great speaker, Anthony Beverly, who works with Stop the Violence, as well as Kia Wright from Voices Corp, to talk about what are some of the issues that drive crime and maybe how we can do a better job of addressing some of the issues that we see in our community. And that discussion will be live and in person, which I'm very much looking forward to. It's been a while since I've seen many of you, and so I'm very excited to be able to get to do that in person. So we look forward to seeing everybody in person. If you still want to join us online, we'll figure out a way to make that happen as well. And a reminder, as always, the fourth week, I'm going to do a presentation on the Crime Gun Intelligence Center and have a conversation about permitless carry. And if you make it to all four, you get a free t-shirt. So not a bad deal at all. I know some of you have all 12. Those are collector items now. I can tell you the t-shirts look pretty good this year. And we're excited to once again get to hand those out in person. So look forward to seeing everybody next week in person. Thank you to everybody who's participated online. And thank you to everybody who's just really worked with us as we've kind of gone through some really challenging times in our community. You know, the pandemic did not slow us down. We still were able to put these together. But I'm very much looking for that opportunity to have those interactions in person. And so we are super excited about that. As I mentioned, today's topic is the topic of consent, which is kind of a heavy topic. And we needed two outstanding speakers to be able to have that conversation. I'm just incredibly grateful for the individuals who are willing to come in and have that conversation. We have two rock stars in our community who do a great job in their respective roles. I want to first introduce my colleague at the prosecutor's office, Katie Melnick. Katie is a deputy prosecutor in the Marion County Prosecutor's Office. She's the supervisor of the Special Victims Team. That means she's the supervisor of all the domestic violence cases, sex crimes cases, and child abuse cases here in Marion County. Before she moved to Indy, she worked in the Manhattan District Attorney's Office for a number of years. She attended Columbia University, and she is a two-time All-American in basketball, from what I understand. And maybe she can fill you in on that towards the end of the show here today. The next person who I'm super excited to have join us is Rima Shahid. She's the CEO of Women for Change, and is just an outstanding leader in our community and really just a tremendous advocate who does a great job of advancing the cause of women in our community and making sure that we have thoughtful discussions at the State House about what issues like consent mean, and was really one of the leaders in terms of making sure that our law was amended in a way that better reflects the challenges that we face sometimes as it relates to criminal prosecutions. A little bit about Rima. She's the first executive director of Women for Change, and she's led the organization's initiatives to educate, equip, and mobilize Hoosiers to create positive change for women since 2017. In that time, she's worked with her board of directors, staff, and volunteers to make Women for Change a respected and expected voice for women in the community and in the halls of power. She's a native Hoosier of Pakistani descent, and she previously served as executive director of the Muslim Alliance of Indiana. She's a nationally sought after speaker and political commentator. She attended Indiana University, Purdue University at Indianapolis, and she lives with her husband and 3 children in Cincinnati, or in central Indiana. And I have to say her dad is pretty cool too. So she's got a great family. She does a lot of tremendous good in our community. And so I will turn it over to our 2 incredible speakers. Before we officially get started, just a reminder to everybody, if you have questions, put them in the chat. Michael Leffler is going to moderate those questions and we'll get to those at the end. But without further ado, I will turn it over to our world-class panelists to have this discussion. Take it away.
Thank you. Thank you for the opportunity. It's a pleasure to be here.
Yes, thank you. Unfortunately, I do not play basketball, as Mr. Mears is aware. I have the height, but none of the technical abilities, and I'm quite clumsy. So, but we are very, very excited to be here and talk to you all about this today. I think we're going to start with talking a little bit about the history of rape and how it came to be. I know PowerPoints tend to be a little bit boring, but so is listening to me talk. So I wanted to actually get something visual so you don't just have to stare at my face. But I want to talk about where rape jurisprudence came from, because the history of how we got here and what rape was and how it started is really important when we talk about consent. So way back in the day, when rape laws first came into being, they were actually property crimes as opposed to crimes against a person. And that was based entirely on this idea that a woman was owned by her father and then later on by her husband. So a woman was owned by a man, and rape laws came into being to protect the interest of the man in that woman. So women's bodily integrity, a woman's right to say no, a woman's right to do what she wanted to do was wholly irrelevant in the context of rape when it first came into being. It was solely about protecting a male's interest in his property, that property being the woman. Unmarried women could not be raped if they were not a virgin. So again, this has to do with the property. The woman being a virgin made her more valuable. And so if she wasn't a virgin, her value was decreased. Her value as property to her father and her eventual husband was decreased. And so that was not even rape at all. And then a married woman had absolutely no right to say no, again, because she was owned by her husband. And so you can't destroy your own property. And so because of that, there was no such thing as rape of a married woman by their spouse. And so that's sort of how rape laws first came into being. And so when we talk about consent and what rape was, it's important to keep in mind that it had nothing to do with consent way back when it first came around. And if we want to advance to the next slide. So what does all this mean, right, in the context of what was illegal? First of all, men couldn't be raped, which you'll frequently hear people to this day talk about rape in the context of the female victim and the male perpetrator. That is absolutely not true. Anyone these days can be raped and anyone can be a rapist. It's important to keep that in mind. Under those theories, where it was a property crime, rape of orifices other than the vagina were not legally recognized. So what that means is that if someone was anally penetrated, orally penetrated, it simply wasn't a crime. It all had to do with the vagina and the bodily integrity of the property and that woman's virginity. And use of force was required. Essentially, you had to establish that the act was against the will of the woman. And so you had to establish force was used, and that was based entirely on how much the female resisted. And so in order to be a crime, to prove a crime happened, you had to prove that the woman resisted as much as possible, which meant then that there had to be visible injuries on that woman's body in order to show that she resisted and therefore was damaged property. Some other interesting facts to sort of keep in mind when we're talking about rape and rape jurisprudence and where we came from. Most states excluded Black women, free and enslaved, from rape laws. Black women could not be raped under those laws. basically because if they were enslaved, they could not refuse sex with their masters or testify against them in court. So this is the same way that a woman could not be raped by her husband because he owned her, and so she had no right to say no. A woman who was enslaved, a Black woman, could not be raped by her master because in the eyes of the law, that individual was owned by that enslaver, and therefore he could not commit a property crime against her. Unfortunately, because of racism, that actually persisted even after emancipation. The law continued to say for quite some time that Black women had no say over what happened to their bodies, and white men could essentially rape Black women with impunity. And just a fun statistic, it was not until 1861 that a Black woman could even file rape charges against a white man, which is really staggering when you consider that 1861 was not as long ago as a lot of us would like to think. And so it wasn't until 1861 that that even became a crime in and of itself, but again, all based on the idea of property. So the manner in which rape was defined, and we always want to talk about the definitions. Lawyers love their words, and we always talk about the definitions and the statutory meanings, because what I think is rape is wholly irrelevant. It matters how the legislature has defined it, because I can only prosecute someone for rape based on how the legislature defined it. So talking about rape and what it looked like under the common law is important. Because that is what would be prosecuted. So number one, we have this idea that it's a property crime, and it's based on a woman being owned by either her father or her husband. African-American women could not be raped at all. And this is how they defined it: as carnal knowledge of a woman 10 years or older, forcibly and against her will. And so you see in there the force, you see in there that it had to be against her will. And again, that goes back to the woman was required to resist in order to prove that this was in fact, in the eyes of the law, a rape. You'll also note that the age of consent was 10 at that point for rape, which is incredibly young. I have a 9-year-old daughter, so 10 is very, very young. That was eventually changed to 14, between 14 and 18, state by state. Every state as of today has their own definition of the age of consent. In Indiana, you will not see an age even today within our rape laws. That is because we have separate laws that apply to children who are younger. So we will get into that when we talk about the current statutes as they're on the books today. But back in the age of common law, the age of consent was 10. So when we talk about how slowly rape jurisprudence has changed, Sir William Blackstone, back in the 1700s, defined rape as carnal knowledge of a woman forcibly against her will. The FBI had that same definition until 2013. So I said that the 1800s wasn't that long ago. 2013 was really not long ago. And that is how the FBI continued to define that definition. So as you can see, sometimes change is slow, much slower than it should be. So let's look at Indiana specifically, because as I mentioned earlier, what I think is rape, what Prosecutor Mears thinks is rape, is not relevant in terms of prosecuting the cases. We are bound by the laws as the legislature described them. So cases can come in and I can say this is horrible and I think this should be illegal, but I can't do anything about it unless the legislature has defined that as rape. And so in Indiana, until 2014, rape was an act that could only occur between the male sex organ and the female sex organ. So specifically, rape only involved a penis and a vagina. This is not to say that other forms of forced sexual conduct were not criminalized. They were absolutely criminalized. They were criminalized under a law called criminal deviant conduct, but we only defined rape as penis forcibly entering into a vagina. Anything else was classified as criminal deviant conduct until 2014. Starting on July 1st of 2014, that definition was changed and rape was expanded to include sexual intercourse as well as other sexual conduct. And so we can look at what that definition was until July 1st of this year. So this goes a little bit back to why people were so protective of rape. Everyone says that it's an accusation easily made and even harder to be defended against. And so this is sort of why way back, everyone talked about and considered this idea that women had to be injured, basically because the concern was we wanted to protect the men who were being accused. What you do not see here is anything about the women, anything about their bodily integrity, anything about their ability to say no or to consent. It's all about protecting the alleged rapist. And the concern was in making sure that the alleged rapist was not falsely convicted. Now, to be clear, every prosecutor will say it is important that the state be held to its burden. No one is out here looking to hold people wrongly accountable. Absolutely not. All we are trying to do here is even the playing field so victims aren't also criminalized. Within this dynamic of the traditional context of rape jurisprudence, the idea was women lie, so we make false rape allegations, men have to be protected. And as a result of that, not only did you have carnal knowledge forcibly against the woman's right, only sexual intercourse, only women could be raped, only penetration of the vagina by a penis was considered rape, but you were required to make prompt complaints to law enforcement. You needed corroboration of the victim's testimony by either independent testimony or, again, that serious physical injury. And there were cautionary instructions which would call into question the victim's credibility to juries. So what that means is if a woman met that bar to be able to accuse someone because it fell within the statute as it was being defined and a case was filed and they got to trial, so they made that prompt complaint, there was corroboration, they got on the stand and they testified, the jury would literally be told, by the way, be careful, maybe don't believe them because this allegation is really easily made and we want to make sure that this woman is not lying. So I want to talk really briefly about strides made. And I see a question, this was until what year? So we're talking about back in common law period. So this was never a recent thing in Indiana. The most recent thing in Indiana until 2014 was rape was only defined as sexual intercourse. There have been a lot of strides nationwide and in Indiana made in sex crimes reform that we can look at really quickly. You have the gender disparity. So as of today, most states, including Indiana, have expanded that legal definition of rape to eliminate disparities based on gender. So as I just said, in 2014, Indiana expanded that definition of rape, and now men can be raped within Indiana itself. It includes other acts beyond penetration of the vagina by a penis. As of 1993, all states, including Indiana, removed the marital rape exemption. So it is no longer legal to rape your spouse. And as of 1993, it is not. It has been illegal to rape your spouse, meaning a spouse can be charged and convicted for raping someone they are married to as of 1993. There are rape shield laws in all states as well. And what that means is prior to rape shield being passed, within a jury trial, the victim's sexual history was allowed to be used as character evidence against the victim. So essentially, if that victim disclosed rape at trial, the defense would be able to bring up every single individual that person had ever had any sexual contact with, consensual or otherwise. And that was a huge bar to reporting for a number of reasons. That's very private information. There are many people that don't want to share that. And a lot of people were scared that things would be used against them at a trial. And so the federal government passed what's called the rape shield law, and every state has adopted it. It must be as protective of the victim as the federal law. Indiana has one as well. And so as of today in Indiana, when a victim testifies, you cannot bring up their sexual history except in very limited circumstances. Those circumstances are essentially if there's another explanation for the DNA or injury. So if somehow there is DNA that's inconclusive or an injury that could have been caused during the same time period that that survivor was engaging in sexual contact with someone else, so someone else could have caused it, defense is allowed to bring that up. If someone has made prior false allegations, rape allegations against someone, defense is allowed to bring that up. And then the big one is prior consensual encounters with the alleged perpetrator can be brought up. That's a bit unique when you think about it. There are very few areas of the law where we are allowed to use propensity evidence to prove that it is more likely that someone committed a crime. In fact, you can almost never get up in court and say that a defendant has done this before, so therefore they are more likely to have committed it this time. That is absolutely allowed. You will never see a prosecutor do that. It is unethical. You cannot bring up a defendant's prior history in court except under very limited circumstances, and you can never use it to say because he or she did it before, they are more likely to have done it this time. And yet the rape shield laws nationwide and the federal rape shield law do allow a defense attorney to bring in the fact that a victim previously consented to sexual intercourse or other sexual conduct with the perpetrator. And that is every state. Cautionary jury instructions have been banished in almost all states. And in Indiana, case law has prohibited the cautionary jury instruction. So as of right now, you will never get that cautionary jury instruction. That was another huge bar to reporting. And so victims of sexual assaults are treated in the same manner as victims of every other crime when the judge is laying out the jury instructions, and there's no specific instruction to tell the jury to be mindful or caution when believing that rape victim. And the prompt complaint requirement and the corroboration requirement are entirely gone as well. What that means is that there is no duty to make a prompt complaint. In fact, statistics tell us that many victims do not disclose immediately. Victims of child molestation almost never disclose immediately. Victims of sexual assault frequently don't disclose immediately either. And when I talk about sexual assault, I'm talking about 16 and older. And so that prompt complaint requirement was a huge bar to people reporting as well, because many people need time to understand the trauma of what they have undergone. There are many people that don't understand that what has happened is a rape, especially if it has happened in the context of a dating or married relationship. And so it takes time for the individual survivor to understand the enormity of what has been done to them, to come to terms with that, and to be willing to go forward and make that report. And that corroboration requirement means that women no longer have to resist. And likewise, men no longer have to resist. You do not need visible physical injury in the eyes of the law to go forward on a rape case. An important thing to keep in mind is that none of this has anything to do with how the jury considers these cases and these victims when they testify. So just because there is no requirement to make a quick complaint, just because there is no requirement that there is corroboration, does not mean that the jury doesn't want it, or does not mean that the jury doesn't ask about it or defense attorney doesn't ask about it. In every single case I have ever tried where someone delayed coming forward or there wasn't corroboration, absolutely that comes out at trial, and absolutely those are reasons that juries consider and sometimes use to acquit. It just means that in terms of sex crimes reform, it is not a legal bar. So someone can still go forward legally. We can still file that case. It just can still be brought up in court. All right, so let's look at the rape law prior to July 1st of this year. So as I said, 2014, the law changed to expand the definition of rape to include other sexual conduct, in addition to sexual intercourse, allowing men to be raped in Indiana. And the law remained the same essentially until July 1st of this year. So until July 1st of this year, this is how rape was defined: a person who knowingly or intentionally has sexual intercourse with another person, or knowingly or intentionally causes another person to perform or submit to other sexual conduct. So you see that sexual intercourse as well as that other sexual conduct. When, and these, you need to meet one of the following three things: the other person is compelled by force or the imminent threat of force. The other person is unaware that sexual intercourse or other sexual conduct is occurring. The other person is so mentally disabled or deficient that consent to sexual intercourse or other sexual conduct cannot be given. So you needed sexual intercourse or other sexual conduct, and you needed either force or threat of force, unaware, mentally disabled, or deficient. One of the things you don't see on that is consent. And it's important to keep in mind force, because while we have gotten rid of the idea that a woman or man who is victimized must fight back, we absolutely required force. And that force could be physical, it could be a weapon, but you needed force, unaware, or mentally disabled or deficient. And that was considered a level 3 felony. A level 3 felony in Indiana carries a sentencing range of 3 to 16 years. It is fully suspendable if someone does not have a prior felony conviction, meaning that if someone was convicted of this, they could get as little as 3 years suspended to probation, or as much as 16 years in prison, which is a vast range. So you could absolutely be convicted of rape and be given a non-incarceratory sentence. And that is prior to July 1st of 2022. And we'll talk about how the sentences look now, but they have not changed. You can still be convicted of rape in Indiana and not go to prison or jail. That could be enhanced. Well, so all of these are defined. So sexual intercourse is defined as an act that includes penetration of the female sex organ by the male sex organ. Female sex organ and male sex organ are also legal terms that have been defined in the eyes of the law. Other sexual conduct is defined, and this is what used to be covered under the criminal deviant conduct statute, but it's an act involving a sex organ of one person and the mouth or anus of another person, or the penetration of the sex organ or anus of a person by an object. And an object can be considered a finger in the eyes of the law. So this is how it was expanded to include penetration of other orifices aside from the vagina and penetration by objects other than the penis. Mentally disabled or deficient has also defined severely abnormal mental condition that grossly and demonstrably impairs a person's perception. Youth alone cannot be considered a mental defect, and that was subjective. It is subjective and is based, analyzed on a case-by-case basis. So in order to meet that bar, we are generally looking at someone with a cognitive functioning level far below their age. So when we file under this one, it is usually an adult that has the cognitive functioning of a child. So I mentioned that rape you can be convicted of and not go to prison. It can be enhanced from a level 3 felony to a level 1 felony under certain circumstances. So if the perpetrator uses or threatens the use of deadly force, is armed with a deadly weapon, if it results in serious bodily injury, or if it's facilitated because the victim has been drugged, then it gets enhanced to a level 1 felony, which changes that sentencing range from 3 to 16 years to 20 to 40 years. And it is non-suspendable, meaning that if you are convicted of rape as a level 1 felony, you have a minimum sentence of 20 years in the Department of Correction, as opposed to something that is fully suspendable under that level 3 felony. Serious bodily injury is also defined because, like I said, lawyers love words and talking, so we define everything possible. And so that is something that creates a substantial risk of death or that causes serious permanent disfigurement, unconsciousness, extreme pain, permanent or protracted loss or impairment of the function of a bodily member or organ, or loss of a fetus. Okay, so I keep mentioning change and what has happened. So as of July 1st of 2022, we have a 4th prong of the rape statute. And that 4th prong of the rape statute says the person disregarded the other person's attempts to physically, verbally, or by other visible conduct refuse the person's acts. So we now have 4 ways that you can get to rape in Indiana: force or threat of force, unaware, mentally disabled or deficient, or disregarding someone's attempts to physically, verbally, or by other conduct refuse the person's acts. What this means is essentially no means no. So to be very clear, until July 1st of this year, no means no was not a thing in Indiana, right? That's what you're taught in high school. That's what you're taught in college. You hear that said all the time. No means no. If someone says no, stop. That was not the law in Indiana until July of this year. And again, it is a level 3 felony, as the general rape statute is, and can be enhanced to that level 1 under the same circumstances that the rape statute could always be enhanced to that level 1. So again, that would be deadly force, serious bodily injury, weapon, or being drugged. So that is a huge, huge sea change in the law in Indiana. We have finally caught up with what we have been telling children for decades. No means no. They teach you that in kindergarten. And yet our law did not reflect that until July of this year. What that also means, if we could go back for 1 second, is that, like I said, and have been saying, just because I think something is rape, just because Prosecutor Mears thinks something is rape, if we do not meet the legislative definition, we cannot file that case. So I am not sitting here telling you that prior to July of this year, I thought it was okay for someone to continue engaging in sexual conduct after someone says no. I absolutely, adamantly believe that no means no, and that someone should stop. What I am saying is that until July 1st of this year, no means no without more would not give me the ability to file that case. Something else that's interesting is that case law has always defined force as from the perspective of the victim, which means that we really should have had this no means no on the books well before now, not just because it's the right thing to do, but also because the courts have been trending in that direction. And when I talk about case law, what that means is that something has gone up on appeal and a higher court has looked at it and said, in their opinion, this is what we believe. So the higher courts in Indiana have been saying, hey, force is from the perspective of the victim. If the victim felt they were forced, that should be enough. And so the courts have been saying this, and our legislature finally caught up as of July 1st of this year. Okay, so let's talk about consent, because I haven't heard that yet. So does anyone have any guesses as to how Indiana defines consent? If you want to put them in the chat bar, but I gave you a couple of options here. Positive cooperation in act or attitude pursuant to the exercise of free will. The person must act freely and voluntarily and have knowledge of the nature of the act or transaction involved. Words or overt actions indicating a freely given arrangement to have sexual intercourse or sexual contact. Indiana does not specifically define consent. However, submission to sexual conduct as a result of fear may be sufficient in proving lack of consent. I am not sure, or none of the above. I'll give everyone a minute to put their guesses in, and then we can talk about how Indiana defines consent. We want to go forward. As we sit here today, in October of 2022, Indiana still does not have a legal definition of consent. So we have undoubtedly made huge strides in the rape laws. We have gone from viewing women as property and saying that women could not be raped by their husbands and Black women could not be raped, to understanding that you could be raped by your husband, that men could be raped, to defining it as more than sexual intercourse. We have progressed as far as saying that no means no, but as of today, we still do not have a legal definition of consent, and we still do not have a non-consensual rape on the books. So what does that mean, right? What does that look like? What are the implications? Well, first, it means that we're all walking around at consent. So as I sit here, I've not met any of you in person today, right? I'm sitting in my office. I have certainly not said no to any of you. So I have, as I sit here today, in the eyes of Indiana, consented to have sex with every single one of you. And until I say no to you, I am at consent. On a daily basis, we are all walking around, starting with an assumption that we have consented to sex with anyone that we come into contact with. And that is the law as it exists today in Indiana. 2, sex without consent is not a crime unless there's additional evidence. So unless I have force or threat of force, unless there's some sort of incapacitation, unless there's some sort of mental deficiency, or unless I in some way indicate I don't want to do this, it is not a crime. What that means, again, is that I have to do something to say I don't want to do this. Now, no one, again, is saying that, you know, people should be criminalized or held accountable for rape when they didn't know. That is not what anyone is saying. We're just saying that maybe we need to change how we look at things and have this idea that we are not walking around at consent, and have an idea that maybe before we get to know, someone should be forced to say yes. And so when the law and society only see rape as occurring under physically violent conditions, we are undermining and devaluing the seriousness of the crime. It is not a property consign. It is not a property crime, excuse me. We all have a right to our bodily integrity. We all have a right to not let anyone touch us in any manner until we agree to that. And without defining consent and having strong laws, it's increasingly difficult to hold perpetrators accountable, which can increase the risk of their offending repeatedly. And so again, all of this that I'm talking about has to do with the laws and the books. It does not have to do with the difficulty of proving these cases in court. Because once you get to court and you're proving things beyond a reasonable doubt, these questions still come up. And jurors are still looking for physical injuries, and jurors are still looking for someone resisting with all their will. And regardless of what is on the books or how the legislature defines it, until society starts to see it differently, we are going to continue to have these problems in getting guilty verdicts in court. So what would we like to see? I would like to see us move towards understanding that yes means yes. So no means no, silent means no, maybe means no, I don't think so means no, later means no, yes means yes. Unless someone is actively participating in that, unless someone is letting you know by their actions that they're okay with what is going on, maybe you should check in and make sure. And so we are at no means no, which is fantastic. And I am by no means devaluing how far we have gotten. We have made huge strides in rape reform, but we are not at the point where yes means yes, and we are not at the point where we have a non-consensual law on the books. And I'm going to turn it over to Rima because, like I said, I sometimes tend to be the bearer of bad news. And so I want to end and let Rima talk on a more positive note. So Rima, I will let you go ahead.
I don't think this is very fair. I think I need a do-over. No, in all seriousness, Katie, thank you. I know I learned a lot, and I'm really, really grateful for all the information that I received today. And I'm sure all those that are joining us today feel the same way. I still think I need a redo because going after Katie is not easy by any way. I think that she's a fantastic speaker, very knowledgeable, and just such a great asset to the community. So thank you for that. I'm going to try to turn this ship around in a more positive note. I don't know if I'm going to be able to do that, so bear with me. Women for Change is a grassroots organization. We are 92 county-wide, and we don't have any sort of national affiliate or any sort of organization nationally that works with us. So what does that mean? Why am I telling you this? I'm telling you this because I'm not as prepared as Katie, and I don't have the support to put together such a fabulous presentation. So I'm asking for a little bit of your grace, but I'm also sharing this with you because we really rely on members of our community coming to us and showing us discrepancies that exist and loopholes that exist in our law to help us be better advocates in the State House. And that's exactly what happened, is that we had a group of people come to us and say, there are loopholes existing in our 2014 law, and please take a look at this. please take into account that 1 in every 3 Hoosier women have been reported to being sexually assaulted. And I really want to point out, when we share these statistics, and when I talk about 1 in every 3 Hoosier women, these are only the people that have reported their sexual assault. There's so many people that haven't even reported it. We know that victims go through and survivors go through so much trauma. They carry a lot of burden, and it brings a lot of PTSD. And so we do have a wide majority of our people that are just unable to, for a wide variety of reasons, report their sexual assault and rape. I do want to add that disclaimer into these statistics. And so when you think about that, I would even challenge to say that it's probably higher than 1 in every 3 Hoosier women. I'm a mom of 3. I have 2 daughters and a son, but that doesn't even matter, because I think for all of us, we should all be appalled at the fact that Indiana ranks 4th highest in the nation as far as reported sexual assault among high school girls. 4th highest in the nation. I don't care if you have kids, if you don't have kids, if you know of a child, if you don't, what side of the aisle you sit on, it's unacceptable. What else is unacceptable is the fact that prior to July 2021 or 2022, it was possible, and it still very well may be possible, so Katie, just jump in anytime. We had a young woman in Avon that came to us, and she was graduating. This was back in 2019. She actually had to graduate and walk across and participate in the ceremony with the young person that raped her, because she was not able to go forward with the trial, because the legislature, as Katie pointed out, it defines it for us. And I always think about this young woman and what it must have felt like to walk across the, and go through the graduation ceremony with the young person that raped her. 8 out of 10 people know, we know the person that has sexually assaulted or raped us. 8 out of 10. And so when we're really thinking about the information that Katie shared with us as far as the use of force, you may not see that, right? And so that's really important to point out. And I think that this summer was a doozy for many reasons. Don't usually use that word, but here it goes. It was challenging for so many reasons. And one of the reasons is that 1 in 7 women who are raped end up being pregnant. What does that mean now? After the passage of Senate Bill 1 this summer. So just want to point out some of these statistics, some of the information, some of the challenges that we're up against, but I also want to share again the opportunity that we have ahead of us, and the fact that we have made significant progress as far as getting justice for survivors and laying out what needs to be for future generation of Hoosiers. I think it's really important for us. We had people that came to us and showed us these loopholes. There are still loopholes that exist. There are still great opportunities. And what we did with this knowledge is we were able to launch a project. It went on for 15 months. Coincidentally, the end of the project wrapped up on March 5th, 2020. If any of you remember, that was just 10 days before the world shut down. Excuse me. And it was called the Clothesline Project. And it was by an artist by the name of Monica Mayer, who is in Mexico City. And what she did is she took a traditionally female role of a clothesline, and she went through Mexico City and asked people to write down stories about their rape and sexual assault on there, and they hung them up. I think it was you're not supposed to air your dirty laundry, right? It's bad form. And she did this in Mexico City, and with her permission and her blessing, we were able to do that here in Indiana. And we collected over 1,500 postcards from all 92 counties. Because what we hear in the legislature, because ultimately, as Katie pointed out, the legislature defines what this is. But what we hear from our legislators is, my constituents don't care about. This doesn't affect my constituents. This is an urban problem. This is not a problem in my good district with my good citizens. That just isn't the case. This is not an urban problem. This is not a suburban problem. This is not a rural problem. This is an Indiana problem. And we have to come together to change Indiana law. The name of the artist is Monica Mayer. If you go to our website, it's women4changeindiana.org, and you search the clothesline, it should pop up for you. I'm sure there are faster ways to navigate that website. I don't really like technology, and that's the way that I use. So on March 5th, 2020, when we made that progress, something else that happened that day, and this is something that I'll never forget, and this is why I'm incredibly thankful to have this opportunity of leading this organization. But I had a young girl, she's probably between 5 and 8 years old. And she came up to me and she kind of tugged at me physically. She just tugged at me, and I was like, okay. And she said, "Can I write on a postcard?" And I said what any adult would say in my situation. I said, well, you have to ask an adult that's with you, because this is a really heavy topic. And I want to make sure, as we're advocating for consent, that we have a consent of an adult to let this young child participate in this. And there was someone standing behind her, and she said, yes, I'm her mom. And we just drove down from the region to come to today's presentation. I said, okay. So she wrote on there that I was raped and nothing happened. And I looked at this young girl and I didn't know what to say to her. I usually, it's not a problem that I have frequently. Words kind of come to me, right? And I said, why are you here today? And I asked her the question that so many adults ask children: what do you want to be when you grow up? These are normal questions that we ask of young people. And she said to me, well, I want to work up there. And she was pointing at in our legislature. And she said, because I don't want this to happen to anybody else. And that's why I'm here. It always gets me. That story always gets me, because that young girl was between 5 and 7. Yet, and she went through something that we don't want any young person to go through. And she drove down from the region, Maryville, Cherville, what is it, like 3 hours away from Indianapolis? Most of us do that drive when we're going to Chicago for something fun. She did that to come to Indianapolis and to advocate for herself. And it was remarkable. I'm proud of the progress that we've made, but I want to offer that real change comes when citizens, like the 65 people that are joining us today, help make that change happen. There's only so far that we can get. We can bring these statistics to your attention. We can share this information, but all of us, it's incumbent upon all of us to do our part, to look at loopholes that exist, to think about why we don't have some of these protections. Why is it that other states are doing better than Indiana? Why is it that prior to July 1, on July 1, Indiana joined 19 other states in Washington, D.C. Hoosiers deserve better. Every single one of us deserve better. Why is it that it takes us that much longer? And the only way to move that forward is when people come together. That piece of legislation was really interesting. The final piece of legislation, I believe, was House Bill 1079, and you can look that up as well. You can probably find it on the Women for Change website. But that was a bipartisan piece of legislation. And it was authored and co-authored by mostly women on both sides of the aisle. And I'll also offer, if you live in a unicorn district where your legislator agrees with you and moving Indiana forward in the right direction 100% of the time, please write your zip, like your address, for all of us so we can all move to your district, because that's one unicorn of a district. But other than that, we still need you to take action. We still need you to engage, because even if you live in that unicorn district that we're all moving to, We can have like a nice neighborhood block party. The chair of those committees aren't going to be that way. So I hear people saying, well, I live in this district and I know that my member will 100% on board. Great, give me your address, I'm moving. But your chair doesn't. The speaker doesn't. Other people don't. And so that's why it's really important for us to engage and continue to engage. There are a lot of opportunities ahead of us as far as getting to yes means yes. There are other issues existing with sexual harassment and the Indiana code as it currently stands. I think we can do an entire presentation on that. But the only way to move this forward is one, yes, absolutely vote. Today, early voting started in Indiana in person. So please, please, please vote. But secondly, continue to engage January through March or January through April. You will be surprised at how few of us actually engage with the legislature. And so what that means is that when we're not coming out, when we're not making our voice heard, when we're not advocating, there are other people that are advocating against our interest. There are other people that are advocating against change because they want to take us back into a time where we were not even considered people. Change is happening. It's a slow moving process. It's like molasses. But we are moving the needle forward. So I would encourage each and every one of you to go to our website. Again, it's women4changeindiana.org. We decided we wanted the longest email address in history. And so that's how we landed on that. And sign up, go to the advocate tab and sign up to be an action advocate. You'll get weekly information about what's happening that week at the State House, the status of bills, and how you can help and forward that along. I know all of us abide by the law and none of us look at our phone when we're driving, but if you happen to catch yourself doing that, you can literally just send an email when you're waiting and when you're cursing at 465 for it to be very slow. We all have an opportunity, and I think each one of us can make a difference. But with that, I think we can turn it over to questions and answers, if that's okay.
Thank you both. I think I can echo what's going on in the chat and say it was very informative, and we are all very lucky to be able to sit here in a Zoom chat with two very important leaders in this space. So thank you both for your time today and everything you do. And as the audience has questions, please feel free to keep sending them in. I have jotted them down as we've gone along, but please keep it up and keep going. And so with the first one, Rima, I'm going to direct it to you. One, can you tell us a little bit more about Women for Change, and specifically about the intersection of arts and advocacy, but also when we talk about advocating on an issue such as this, what does that look like? It can take many forms, and I know your organization does approach it from many forms, but I think a lot of people talk about advocacy ending up at the State House, but not a lot of people know what that means. So can you kind of elaborate a little bit about the excellent work that you guys do?
Thank you. So the clothesline, as I shared, it was a 92 county-wide project, and we really relied on the arts community to share the exhibit. The clothesline was traveling, and what was happening, it was going from car trunk to car trunk, and being shared at different art galleries, at community organizations. Big Car had it, the different arts organizations and museums that we have. I'm thinking of a number of ones that are fabulous in Broad Ripple. They shared those. We had them throughout at libraries. And the arts community really uplifted the clothesline project, and usually what I like to jokingly say is that at the State House, you see the usual suspects, right? You see the contract lobbyists, you see the public defenders, the prosecutors, people that represent corporations, the tired advocates, and nonprofits, and different organizations. And that was one time that was really unique because we saw artists in the building. And we saw a lot of those members of that community. And I would like to think that that helped with the passage of that bill. And I think a lot of times what really helps move that needle forward is noise outside the State House helps bring change inside of the State House. When we can get op-eds going, when we can get people sharing information, it takes as little as content sharing. I think a lot of us, we are very upset with social media for a number of reasons. And I'm not trying to dismiss any of those. I think there are serious problems with social media, but we can also use that to harness and use that for good as well. And so information sharing goes a really long way. A lot of people don't know about these statistics. A lot of people don't know about the loopholes that exist. And what we have seen is when you share that information, more people are likely to get involved and do something to change that. And that's how we use our advocacy, is to help bring public awareness that brings public dialogue, that helps bring change. That's what we have noticed our secret sauce is. We like to share the recipe of our secret sauce. But if there are ways to tweak that and make that better, drop us an email and let us know. We by have no means perfected anything. And the only way we can get better is by everyone's engagement.
That's great, thank you. And the next question is for Katie. Can you talk a little bit about how prosecutions, well, I should say law enforcement investigations and prosecutions have sort of changed throughout the years from the change in 2014, how they've looked since, how the new change can affect things, and also how law enforcement and the prosecutions can benefit from a more robust and actual definition of consent.
There was a lot in there. Let me try and break this down. So absolutely. I think the first thing to keep in mind is the change in law is important. Absolutely. Because the law that we charge under has to be the law in effect at the time of the commission of the crime. And so that's why we are always referring to dates, because if a crime happened in June of 2022, it will fall under the old statute. So even if I were filing that case today, if I fell under that fourth prong, meaning I did not have, I would need force or unaware or mentally disabled or deficient. So regardless of when we file, it is the law in effect at the time of the commission of the crime that is relevant. So what that means is that as of July 1st of 2022, if a case comes in and the fact pattern is that the survivor has said, no, 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 I am now able to legally file that case and go forward on that case. Whereas if I got that same fact pattern and I did not have force, or I did not have mentally disabled or deficient or unaware, and that crime occurred in June of 2022, that is a case that we would not be able to file. And so that's kind of how investigations have changed, because we can continue to charge as the law continues to evolve. And so if we were to get, let's say, a fifth prong of rape that said non-consensual sexual intercourse or other sexual conduct, what that would mean is that, let's say I didn't fall under any of those four existing prongs, but I was able to prove it was non-consensual, I would all of a sudden be able to file that case when I wouldn't prior to, as I sit here today. And I think something that we hear a lot, especially from defense attorneys, is, well, how do you prove that something is non-consensual? How do you prove that? And my response is usually, I have never gone to trial where someone says it was forceful, but non-consensual. It was, no one ever, everyone always says it was consensual. No one ever says there was force and consent is irrelevant, or there wasn't force, but consent is irrelevant. And no one ever says, well, he or she said no, but okay, maybe it was actually non-consensual. And so the argument as we sit in court these days, regardless of the rape law, is always from defense, this was consensual, this was consensual, this was consensual, regardless of what prong we charge it under. So if we were to get a fifth prong that says non-consensual sexual intercourse or other sexual conduct is rape, it wouldn't really change how it plays out in court, but it would change our ability to charge those cases. I see a question. Is everyone convicted of rape put on the sex offender list? Yes. So you are required to register for different amounts of time, 10 years or life, depending on what your conviction is. Rape is a lifetime registry, unless there are certain circumstances in which you can come back and ask the court not to find you a sexually violent predator. But basically 99.99999% of the time, if you are convicted of rape, you are on the sex offender registry for life. Now, that being said, if you are charged with rape, or you are accused of rape or not charged, you are not on the sex offender registry list. And so it's tied to the conviction, not the accusation or the filing of charges. I'm not sure if I answered all the questions in there.
You did, and I just sort of threw them all at you at once. There actually was one that's a little bit up in the chat, and I think it can be a good illustration of sort of what you and your team do in court. And they asked, and it was referring back to the PowerPoint when referring to SBI, serious bodily injury. What is that evidence? Like, what is that? What does that look like? What is that burden of proof?
So every crime, regardless of a small theft, stealing a pack of gum, rape, murder, child molestation, the burden of proof is beyond a reasonable doubt. And it is incumbent on the state to prove every element of the crime charged beyond a reasonable doubt, including that the individual we have charged with these crimes is the individual that committed the crime. And so what that means is that I have to prove every element. And when you look at that rape statute, you have knowingly or intentionally. So I have to prove the defendant acted knowingly or intentionally beyond a reasonable doubt. I have to prove that it was the individual sitting in court beyond a reasonable doubt. I have to prove that sexual intercourse or other sexual conduct occurred. And I have to prove that it was force, unaware, mentally disabled or deficient, or that new fourth prong beyond a reasonable doubt. And if I've enhanced it to a level 1, I have to prove again that serious bodily injury or deadly weapon, threat of deadly force, etc., beyond a reasonable doubt. What that looks like at the end of the day, 99% of the time, is going to be testimony. And I say that because we get this a lot in court. We have people who say all the state had was the victim's testimony. And the reality is, regardless of how much additional evidence I have, when I have DNA, when I have serology, when I have injuries, all of that can be explained away by this was a consensual encounter. DNA doesn't tell you that a rape occurred. It tells you that someone was there. Injuries, even vaginal injuries, don't tell you that a rape occurred. It tells you that someone was there. And as Rima said, the vast majority of these crimes are perpetrated by someone that the survivor knows, and frequently by someone that the survivor trusts. And so at the end of the day, in court, it is frequently that victim standing alone saying, believe me, and us arguing, here's why you can believe that person. And so we are frequently left with that survivor's testimony and then surrounding it by as much corroborating evidence as possible to show the jury why you can believe the testimony of that survivor.
Michael, if I may,
Absolutely.
I think it's interesting to point out that part of the genesis behind the bill that was now signed into law was the Purdue case, in which a young woman went into a dorm room and had sexual intercourse with a man that she thought was her partner, someone that she trusted, and after the fact then found out that it was not. And so that's, I think that's something that needs to be pointed out. And Katie, again, correct me if I'm wrong, but the current law would still not protect that young woman, even
Absolutely.
though that was part of the genesis of this law. So I think that's
Absolutely.
it's mind-boggling. I think that kind of the theme behind this evening is, if I have one takeaway, it's Katie's fabulous. My second takeaway is is that a lot of progress has been made, but we still have so much work to do.
And for everyone that doesn't know about the Purdue case, it can seem a little confusing. Rima did a fantastic job of explaining it, but essentially a woman fell asleep in her boyfriend's dorm room. Someone got in bed behind her and she didn't turn to face that individual. And so at the time that they engaged in the sexual intercourse, she was under the assumption that it was her boyfriend because she was asleep in his bed in his dorm room. And when she turned over after is the first time that she learned that the perpetrator was not in fact her boyfriend. And if I'm remembering correctly, I'm pretty sure the perpetrator actually gave a confession in which he said, I know she would not have consented if she knew it was me. However, I knew she would consent if it was her boyfriend. So that's why I didn't tell her it was me. And so that is a perfect example of what a non-consensual sexual assault statute would do. We frequently call it rape by fraud. So you believe you're consenting to one thing and actually someone engages in some other activity that you have not consented to you. So in that case, she thought she was consenting to her boyfriend. The perpetrator clearly knew that she wouldn't consent to him. And that is a case that went to trial. And the defense attorney argued, you can think this is reprehensible, you can hate this, but look at the rape statute. It doesn't qualify this as rape, and he was acquitted. And so that was absolutely one of the reasons that this got started, and that would still not be illegal in the state of Indiana, as we sit here today.
And that actually kind of leads into my next question, which is for both of you. I think, you know, that case is shocking when people first hear it, right? In the circumstances of that and the fallout of that. And also, I think it's safe to say the chat blew up, Katie, after you asked, you know, the question about Indiana's consent law or lack thereof. And so, you know, what can we do, the people on this call do? There are, 60 plus people on this call who are active and engaged and want to better their community and make it a safer place for all. What are some things that they can do?
100%. Today, early voting started. Vote. Take your friends. Take people that say, I don't like politics. Do you like bodily autonomy? Offer that. Do you like bodily autonomy? Do you like safety? Do you like having control over what happens to your body and what that means? I'm sorry, that's one of the hills I will always die on, is I don't like politics. Do you like breathing? Do you like drinking water? Ask our brothers and sisters up in Flint. Everything is political. Engage. Your engagement could be information sharing, as I stated, all the way up to coming to the State House and testifying. I know we're all busy, and our legislature does not make it easy for us to engage. January through March, January through April, Monday through Thursday, 8 to 4. It's when people are working. I understand that 100%. Democracy should be. We should all be able to participate. It's not easy. Finding parking, the weather's crummy January through March. It's snowing. I understand all of that. If you can't make it out to the State House and testify, make a phone call and get your neighbors, get people within your district. Look at the bill. It's going to be made available on our website. I know there are going to be a number of other places where it's available, but look on the website, see where the bill is, call the chair, call members of the committee, and get at least 5 friends to do the same. The power of the citizen is something that I think we don't often leverage enough, and we take for granted. You will be shocked at the responsiveness and how things can possibly change because of your engagement. It's going to mean a lot more coming from the folks that are on this call, and at least 5 people that you're going to enlist, than it does coming from me, because they see me every day. And that's just the truth of it. We need men, we need all people, we need allies. be very truthful when you're talking to your legislators. Be very honest. Share information, share statistics, but also share what this means personally to you. How does this affect you, your family, your community? They need to hear from all of you because by definition, they're supposed to represent you. And if they're stopping progress from being made, then there's a serious problem there. And they need to hear that from each of you. So if you can take at least 5 people to engage with you on these issues, you will be surprised at what a difference you'll be able to make.
I think education also, and this goes to what Rima is saying, most people don't realize this. There are many people that didn't realize we weren't at no means no until July of this year. And I think there are many people that don't realize that non-consensual intercourse or other sexual conduct without more is not currently a crime in Indiana. And I think the more that you talk about it and the more that people are made aware of it, the more that they're willing to be engaged.
We also have an issue-based voting guide on our website. So if you go to our website again and you go to the vote page, because we like to talk about the issues that are on the ballot, not the candidates that are on the ballot. Because for so many people, every single election, thank you, child. I told you I was a mom, and now you got to see a nice shadow of a child. I wasn't lying when I said that. For so many people, you know, they see candidates coming in kind of around election cycle, but their quality of life hasn't changed. Election after election, broken promise after broken promise. Share that issue-based voting guide, use it when you're going to the polls, and share it with other people. That information sharing, that education, that bringing awareness is really really important. It can be transformational.
Katie, I think we can knock out a few questions in the chat with this next one, and I'll leave it kind of vague, and I know you'll hit on it all. But someone in the chat asked about how does special victims do it, and how have success when you face so many barriers to these kinds of crimes.
So I think the first thing that's important to recognize is there is a difference between what crimes we are prosecuting. And so within special victims, we handle physical abuse of children, sexual abuse of children, sexual abuse of adults, domestic violence. And I've seen a couple questions about child molestation. Consent is not a defense in child molestation in Indiana. If you engage in any sort of sexual conduct 13 and lower, that is child molestation. It is not rape. And consent doesn't even come into play. The defendant can get up there all day and say the victim consented. It doesn't matter. That is not a defense. There is another statute called sexual misconduct with a minor, 14 and 15-year-olds. Those are the victims who are protected under that statute. And again, for the most part, except under very limited circumstances, consent is not a defense to sexual misconduct with a minor. So it's really only the 16 and older where we're dealing with rape. Now, in terms of success, these cases are hard. We do a lot of juror education. And so when I talk about education, there are a lot of things that we hit on when we're selecting a jury during voir dire to try and make sure that those jurors understand that these cases generally boil down to the testimony of that survivor. And that at the end of the day, I can have DNA, I can have injuries, but all of that just corroborates what the victim is saying, and they don't prove anything. So you have to get behind, you can convict on the basis of the victim's testimony alone. So when I talk about education, you guys are pivotal because you can go out and tell people, hey, in rape cases, it's about the victim's testimony. It's about getting on board with believing that victim. Are you aware that there usually aren't physical injuries? Are you aware that there usually aren't genital injuries? Because people knowing that and the community understanding that and understanding that what they're coming into isn't a Hollywood movie or an episode of Law and Order SVU is hugely important, because the things that we see in Hollywood and the things that we see on TV and this narrative of the boogeyman in the bushes is not what the average rape case looks like. The average rape case looks like a survivor who has been sexually assaulted by someone they trust, someone that they never thought would do this, and they're getting on the stand retelling often the most traumatic thing that happened to them. And everyone reacts differently to trauma. There are individuals who cry. There are individuals who have problems with their memory. There are individuals who lose memory entirely. There are individuals who become very stoic. There are individuals that giggle. So their response and what you get out of that person on the stand is not going to be what you would get from a trained actor and actress. And so it is making sure people in the community realize and understand and have different expectations of what a rape looks like. And so all is not lost. We file these cases, and frequently what I tell survivors as they go into court is, we would not be here if I didn't believe you. And sometimes victory is in that survivor getting on that stand and talking about what happened to them, because at the end of the day, rape is a crime about power and control. And the second that someone discloses, the second that someone goes forward with the investigation, the second that they take that stand, the perpetrator has lost, because that power and control dynamic has been switched. And so the second that that survivor walks into that courtroom, they have won. And so that's something that I talk about. Sometimes our victories are not just in the verdicts, not that we don't get guilty verdicts, because we have fantastic results and every single prosecutor that I work with is fantastic, but there are days that you lose trials, and that doesn't mean that you have lost or that that person did not commit this crime, because that survivor has won by coming forward and testifying. I would also say the other thing to keep in mind that I frequently talk about is that not guilty is not innocent. And so at the end of the day, it is the state's burden to prove the crime beyond a reasonable doubt. And something that I frequently talk to survivors about is, if a jury comes back with a not guilty verdict, it doesn't necessarily mean they don't believe you. What it means is that I wasn't able to prove it beyond a reasonable doubt.
Another good question from the chat. Katie, first of all, thank you for that answer. And another good question in the chat is, are there any states that have a consent law or a positive example, or anything that we should mirror or use as a basis for our advocacy?
So as Prosecutor Mears mentioned, I'm from New York, so I frequently go back to my days of working at the Manhattan DA's office. New York has a non-consensual rape law. It literally says, I believe it's rape in the third degree in New York, and it just says non-consensual sexual intercourse. And not that New York is perfect by any means, but they do have that law on the books. And there are many states that have non-consensual sexual intercourse laws on the books.
Another one that just popped up that both of you guys can answer if you'd like is, how effective do you think rallies and protest groups are in the legislature, or are writing letters or personal contact better?
This one kind of excites me right now, because the injunction that was passed, just very recently around Senate Bill 1, which was the abortion ban, the Republican judge from Owen County, in part of her remarks that she stated when granting that injunction was the community's interest in the case, and not having the government restrict these very private decisions between a person and their doctor. That I'm paraphrasing right now to find her exact words. I would say just Google them, but she referenced that. And what we did this summer with our partners over at the ACLU was mobilize thousands of people and show that this is something that we don't want, Hoosiers don't want. And that was very, very effective, because 7 days after the abortion ban went into effect, abortion became legal once again in the state of Indiana. So we have found that to be very, very effective. But yes, I think in addition to protests, those personal phone calls and those that outreach is also really effective. This year we saw with the CRT bill, thousands of emails being marked as spam. So I would say if you're using an advocacy tool, we have an advocacy tool that we use on our website where we're also encouraging people to not necessarily just use that advocacy tool, but also write their own emails and make their own phone calls, because now our legislature is marking some of those populated messages as spam. They are very, very effective.
And I always like to end this question, especially with, as I said, two great champions of the cause, like with you guys, is, we are talking again about a topic that is very, heavy and personal, and can be a lot at all the time. And so one, can you tell me a little bit about why you guys can, do this every day, advocating on behalf of women? I know, Rima, I saw you everywhere this summer. And Katie is in the courtroom every day, including about 5 minutes before she hopped on this call, advocating on behalf of women and victims. And so can you guys just tell us a little bit about why you guys, fight the good fight?
Katie, I'll let you go first.
Okay. I think that it is an honor and a privilege to be able to talk to survivors and offer them hope in some of the worst moments of their life. And to be able to walk into a courtroom with someone and let them know that you believe, when sometimes no one else has ever told them that, and that you are going to get them through that. And regardless of the outcome, their healing, their justice does not ride on what that jury verdict comes back as, that they have already won because of where they are, because they are strong enough to come forward. They are strong enough to get on that stand. And so to be able to do that every single day with children, with victims of rape, with survivors of violent crime perpetrated by people that they love is I think one of the most incredible privileges, and is just an amazing thing to see. And some of the most amazing things that I've ever seen in a courtroom are the strength that come from these survivors as they take to stand. And it is just incredible to be able to witness that.
I knew I should have gone first. She always does such a great job. I echo that. It is an honor and a privilege. And I think of my children a lot. And as parents, we always want to leave the world in a better place for our children. And that's why I do this. I absolutely love Indiana. I'm going to tell you a secret, and that secret is that people don't come to Indiana for our white sandy beaches. People don't come to Indiana for our beautiful snow-capped mountains and our wonderful, world-class skiing. They don't come for amazing amusement parks, but they stay in Indiana because we have a good sense of community. We value one another, and we build a really good place for us to all live and thrive. And I want to do my part to make sure that that continues to happen.
Thank you both for sharing, and thank you both so much for your time. I think I echo everyone in the chat and on this call in saying that it's been an honor and a privilege to listen to you both and learn from you both tonight. And thank you for being participants in our 12th Annual Community Justice Academy. And with that being said, I'll close this out here very shortly with, I hope that everyone can join us, and those who wish to join us next week, about the root causes of violence. This will be our first in-person session since 2019, and we are very excited. We have two more excellent speakers and pillars in the community to come speak about an issue that affects us all and that we all care about. And if you are unable to make it next week, don't fret, don't worry. We will have the session available on YouTube, hopefully by the next day, so you can watch the recording as it lives there forever. So I want to thank everyone for their time in this evening, and our speakers, Rima and Katie. Thank you both so much, and we'll see you guys next week.
Thank you.